Well, the end of the music means we're live, I believe.
Let's hope so.
So it doesn't look like we have any viewers yet, but we wanted to get together today because this week has been maybe say monumental or hectic or what other adjectives are there to describe how this week has gone?
A year. I mean, that's about how it's felt. I think I've aged a good bit. And, I appreciate first, I want to give a shout out to our team. I know Karen Osborne and Austin Hatcher, our two other attorneys, have been working their tails off. Not to say that I haven't either. And you've been working with Katie and Ryan to make sure that we get our messaging out. And, PJ's been working the back end. And the forgotten intern Caleb, he's down there. He's trying to organize us. He's trying to do some background research. So, while this has been an extremely, we had 3 to 4 crises that I think started on Thursday, and some of which are actually potentially officially terminating today. One of which was terminated earlier this week that we'll talk about, and a couple that were starting back up. So, it's the beauty of our work is it's cyclical. It's like a life cycle. You kill a tree, but it sprouts a seedling, and something else pops up in its place. And so, I don't know. It's kind of cool to look at it in that perspective.
Right.
It's exhausting to look at it from any other one.
For sure. Now, I think a lot of our followers, at least it got a lot of traction on social media, and we were a little abrupt in the way that we presented it to our followers as far as SMF V Inslee goes. It wasn't necessarily intentionally made it a very abrupt announcement about it being finished, completely dead, whatever the wording was. But I think we owe it to those that have been following along with that particular case to discuss where that's at. I think we said it's officially dead, but that doesn't necessarily mean we're done fighting that particular fight.
Yes, and yes. I will say. So SMFE Inslee, for anyone joining us for the first time or who's forgotten it, is about Governor Inslee's COVID-19 emergency proclamations issued in March of 2022. Specifically, at the time, there were a handful of counties that had either 0 COVID-19 cases or less than 10. And we sued him back then or shortly thereafter saying, hey, look, the governor's emergency powers statute, the law, revised code of Washington 43.06, has some guiding principles. And those principles are that he has to declare an emergency in a location. And when that emergency is done, it terminates. He doesn't terminate the emergency, it terminates. And it's supposed to be location dependent. And that was the bulk of our argument was that, look, he declares a state of emergency in Washington. You have some counties, many were smaller, Columbia County, I think 3,900 and change people, very rural. I think Asotin, also a very rural county. Regardless of what the inhabitation is, the whole state of Washington was under emergency proclamation, and some counties had 0 of this emergency. Now, we know that COVID came and went, and there's a whole separate conversation that we could have about whether or not those numbers were always skewed or just usually skewed.
Right.
But needless to say, the pandemic was there, and our claim was, well, listen, it's not there if there are 0 cases being reported. And we sued the governor and said, hey, we need clarification on what the term used in the statute as affected areas, these locations are. And we pressed for define affected areas. Well, there's a 1981 case about Mount St. Helens that talks about that and how the volcano was dormant, but it could erupt and all these sorts of things. And it's like, COVID's different here. And you and I have discussed this on several podcasts. It was managed very differently. It was managed geographically from time to time. And so why is this one different where there's a statewide state of emergency when there's no COVID in certain places, literally the day he's declaring it?
Right.
And so that's the nutshell version of SMFE Inslee, talking about these emergency powers and trying to rein them in, because we know that over the 2 years of the pandemic, that the legislature refused to do anything.
Yes.
And let's be clear. It was both sides, but certainly It was the Democrats. I mean, the Republicans, they have what's called the four corners. I mean, the Senate leader, Senate minority leader, Senate, the House Speaker, and the House minority leader. They met, and my understanding was basically Lori Jenkins, the Speaker, and I can't remember who the Senate leader is. I want to say it's Andy Billig, but I don't think it's him. Regardless, whoever it is, we're like, no, we're not going to even really take the phone call. And we're going to walk away, and the emergency's we're not going to touch this. We're not going to undeclare it. We're not going to modify his powers.
So, I mean, to break it down for someone dumb like me, a layman, basically what that sounds like is what, as we currently stand, the governor, whenever he declares an emergency, is essentially setting up his dictatorship. He can decide what is or isn't and what's going to happen within those parameters. What is there to check him in these emergency powers, if anything?
Well, so certainly you've got it right. That's the effect of it. We see a uni dictatorship, right? Where one person controls all the decisions. What is supposed to check him would be these statutes that say this is how it automatically terminates. It automatically terminates. I don't want to miss that point. Like, once he doesn't undeclare the emergency, the emergency goes away and undeclares itself. And well, I want to thread back into this thought that there are emergencies that are currently statewide declared that don't exist. Not just the pandemic, but we talked about this on a podcast that didn't record.
Right.
About the Spokane fires. And I think that's really, really important to discuss, again, so that we understand. And quite frankly, maybe I'm crazy, but like I'm always on my toes of like, what's the next one? What's the next one? What's the next one? You know, we've talked about climate change, and we know that's a big issue.
Well, that's not just a theory. We know that when he declared the fires an emergency, a statewide emergency, by the way, which is still in effect as of yesterday. I didn't check today, but as of yesterday, we still are in a statewide emergency due to the fires that happened, are no longer happening. He did blame climate change. He did bring that into his rhetoric when he was declaring an emergency. So that's not just a theory. That's not just a what if. That is exactly where this is headed if these powers aren't checked.
Yeah, exactly. And so again, back to your question, you know, theoretically the legislature puts the governor in check, and life's good. And, you know, a lot of states, as we discussed, again, I don't recall if it was on the podcast that it didn't have the audio, or if it was in other ones or both. You know, other states adopted these, you know what? These unilateral decision-making processes are not good for the people. We're going to go ahead and check the governor every 30, 60, 90 days. There were several states, both red and blue. This wasn't a political thing, where they realized that the governor having that much control, that much unilateral authority was not good for the people of X, Y, or Z state. And so that's how it's supposed to work. And again, back to it, the Democrats, as I was informed, were unwilling to meet. Several bills came forward, primarily from Republicans. There were a couple, I think, moderate Democrats that actually brought forward or supported bills to not rescind the powers, but to limit them, again, in this time check. And so with that, you know, we brought the lawsuit saying, hey, look, we understand that March of 2022 is gone, but we think this is still live because there's a concept in law called mootness. And we got to hone in on this because, you know, the death of SMF V Inslee was the death of mootless. It's like blunt force trauma with your shoe.
Right.
Okay. It's not saying bang, bang, you're dead, you're an idiot. It's, yeah, we see your point, but it doesn't exist anymore. Like the boogeyman ain't in the closet, you know?
Right.
No monsters under the bed. So who am I scaring? I'm sure we all feel that way when it's 10 o'clock at night and we've yelled at our kids to go to bed and they're asking them to crawl around the room, right? Yeah. Just stop. It's not there.
What's interesting about the mootness point from my perspective is that there's two things. One, the emergency proclamation still stands. COVID-19 emergency proclamations, I think I sent it to you the other day. It still stands. It's still there. It's not inactive. It is an active emergency proclamation. I don't know what teeth it has or what enforcement they're actually have under it, but it is still an active proclamation. So technically, I don't know if they really can call it moot. I mean, obviously, I'm not the lawyer here. The other thing is that the statute, we talked about this a little bit with the fires, the statute demands that he he determined where the emergency is, and then once order is restored, to then rescind the proclamation. It sounds like he's not following that, and the courts are not going to enforce that part of the statute.
Yeah, I mean, I'll say this: I can't speak to the emergency proclamation on COVID-19 because he terminated the state of emergency from which the emergency proclamations were appended, right? So theoretically, whether or not he rescinded those, they should have died on October, and this is part of why we kept the case alive as long as possible. He didn't rescind this until October of 2022,
Right.
and again, we're challenging stuff from March. But yeah, when it comes down to it, in looking at the Spokane fires, and again, we're clearly sympathetic to people who've lost loved ones, property, school, whatever. Fire is very damaging. It's disruptive. There's no question that, especially while it's burning, there are resources needed, and no question that while after, you got charred land, and again, pointing to a school. The school no longer exists. You can't go to school there, and so you're now having resources to bus kids or whatever the case is, convert a temporary shelter, whatever. But the point that we've raised in this, and this is why it's interesting, I'm going to read a line from what the judge in Thurston County said. And you and I were talking about this, and you pointed it out to me, and it just made me remember the case even better. While a fire or a flood may affect a particular area of the state, which may be one or more counties or some other area, those events may impact others as well. This is the judge talking. An example I've come up with that doesn't apply to this case, meaning the global challenge of COVID-19 and how she claimed it was aerial and it was transboundary, right?
Right.
It identified as they/them boundaries. And an example that I've come up with that doesn't apply to this case is a flood in Lewis County that causes an extended closure of I-5. That may have severe impacts in other parts of the state, even though beyond the flooded area. Here, the issues surround an airborne virus that may have impacts across county lines. And so again, her comment, the judges in Thurston County, was basically like, look, there are instances, and she ironically, well, not ironically, I mean, just so happens that fires have happened since, right?
Right.
And
Well, I would say fortuitously. I mean, she uses a phenomenal example of what these powers are meant for,
well, exactly,
and what they're intended to do given specific emergencies.
And the interesting thing about the fire proclamation, again, unfortunately, I didn't print that out, but we did talk about it, and so since no one heard it, we'll talk about it now. Those proclamations talked about fires burning in Spokane County, in the northeast of Washington, and I believe in eastern Washington. It did identify it was a statewide emergency that identified certain localities. And we discussed this. Well, is this the one to bring a lawsuit on, right? And it's like, man, we're going to look really bad here suing the governor for letting firefighters go fight fire mid-August, because winds can change, and we know that. But I think it's important that we find something. I mean, the judge, again, gave us the roadmap, fires and floods. And again, I don't feel, it's not that I lack sympathy for people who are flooded out or burnt out or lose loved ones in such events. But I mean, I've talked about this. My sister lost her house, right? It's totally displaced her husband, and her 4 young kids. And now they're a little older, but it wasn't an easy life. So again, I don't want to sound like we lack sympathy for people who are caught up in these natural disasters, but looking at the way the judge gave us the roadmap, clearly a fire in Spokane County should not be a statewide emergency, unless, to me, the governor could have, and I'm not playing Monday morning quarterback, I'm playing legal analyst quarterback here. Mm-hmm. He could have declared it in that place and, made, you mentioned this, like the adjutant general or whatever, state kind of military forces and our militia, mm-hmm. Mobilized. And he could have done that. He could have given the resources without a statewide emergency, because he could have given other resources elsewhere.
So that's clearly defined, right? It doesn't have to be a statewide emergency for him to allocate those resources.
Right. You can give relief regardless.
So it really, in my mind, it bothers me that that he does declare a statewide emergency in the event when it's not a statewide emergency without care.
Absolutely. And again, this is why, okay, so SMF V Inslee's dead. Okay, right. I mean, I remember my mom reading Rosencrantz and Guildenstern is dead. I don't remember what it's about. It's like a Shakespeare play. And I just remember the title as a kid thinking it must be cool. And it was Shakespeare, so it wasn't. But that's what this is. Yeah, our case is dead, but there's so much to take from what the judges said. They laid out a really great discussion about mootness. Again, mootness is the legal principle that there's no longer a live case, right? COVID's gone, the emergency proclamation's gone. He undeclared the COVID-19 state of emergency, like the global one, which took away these emergent states of emergency. Now, the question is before the court that we had was, well, you're right, Your Honors. We were aware that this emergency proclamation had died, and so had the COVID emergency. But we have an issue here. It's an exception to mootness because while this case and controversy is no longer live, Your Honors, have the ability to put the governor in check. And there are two exceptions to mootness. And one is that it's capable of repetition. In other words, it can occur again, yet it evades review. In other words, it can happen again, and no one's there to really help us, guide us through it. In other words, the court is avoiding academic questions. If this can happen again, and the court needs to put some sort of box around this, then it's appropriate to hear it, even if it's moot. There are a couple other exceptions, but those are the ones we really rested on. And the judge said, you know what, or judges, there's one judge and two concurring, meaning two agreed with him, said, listen, it's moot, pandemic's over, and we really don't see a value in kind of writing a law, drafting a law, or checking a box to talk about whether or not because we challenged COVID proclamations, not some global emergency proclamation that we believe COVID will recur, but it's not going to be COVID-19, so it'll have to be retitled COVID-23.
Right.
So same proclamations, just new ones.
Well, there was the finishing paragraph in that decision about it unlikely to reoccur, right? I mean, you have it right there from a judge saying that this situation is unlikely to reoccur.
Yeah,
I'd like to know, really, be the fly on the wall when we're making that decision and thinking that through. What makes them think that this isn't going to reoccur? What evidence are they using that there's not going to be, especially when we have so-called experts talking about the next pandemic already?
Yeah, and I obviously I disagree with that, and I don't really have a response to that. But yeah, to your point, it's just basically, it's finally the COVID-19 pandemic was a unique circumstance that is unlikely to recur. Because the state of emergency regarding the COVID-19 pandemic has ended, there is no continuing question of great public interest present in this case. So because the good king said it's gone, there's no public interest. And to your point, I mean, I'd love to go to these judges and I don't care what news you're listening to, whether you're a Fox, an OANN, or CNN, you're going to hear about the next pandemic variant.
Right.
I mean, dude, we read every week about these stupid Department of Health letters. Get your boosters, get your kids shot. Oh, right. And it was last week that we talked, or the week before, what was it? 2 for less than 6 months and triple for up to 2 years, I think, were the shots and kids. Boosters.
Yeah.
I mean, so there's no emergency, Your Honor. Why the heck do my kids need 3 shots? Right. I mean, what other shots do you get 3 right away?
Yeah. Well, the whole process behind the COVID vaccine and the funding that is behind it, everything about it was funded by taxpayers. So that's our money. No one talks about it's free or the government's paying for it. No. We, the taxpayers, paying for it. That's where our money's going, and it's going right into the pocket of those rich pharmaceutical companies for a vaccine that has little, if no, support scientifically for its efficacy. And now we're getting a new variant of the booster for the fall because the other ones didn't work, and it's a mutating virus, and all the other explanations and excuses they have for why we're going to continue to give ourselves these shots continuously. I even tried to look up what fully vaccinated meant via the CDC. Uh, their definition is murky or muddy at best. The best I could understand was that basically you need a shot every 6 months, is what they're saying.
Yeah, I mean they're the perfect poster child of muteness. They are capable of repetition yet evading review. Right? You can't define it.
Right.
It's as bad as the word woman.
Oh man, I still haven't figured out what a woman is, and I've got 6 daughters, so I better figure that out pretty soon.
Well, you said have 6 children.
Oh, 6 children. They
Yeah.
haven't told me.
Yeah.
But I'm pretty sure they've confirmed what their gender identity is right now.
Right.
I guess that's subject to change if what everyone says is true.
Yeah.
So we've got some other topics. This one was kind of burned hot and bright really quick, and I think it's off our plate officially today. But I want to go over it. There is a small community in southeastern Washington, Dayton, Washington, that had some major controversy. It still has. I assume the controversy maintains, but we've kind of exited the conversation as of right now over their public library down there. You want to go into that a little bit?
Yeah, and the reason I'm swiping through my phone is I'm looking to see if I've got a confirmation email that what we filed today was actually filed, and I'm not seeing that yet. So it's officially unofficial. So yeah, there was a community, and there were issues related to children's books that have sexuality and the stuff that we see fought in schools by Moms for Liberty, who the plaintiffs called terrorists. Well, the plaintiffs cited the Southern
Poverty Law Group.
Yeah, for calling them domestic terrorists. Moms that want to teach their kids what sexuality is. God forbid they do that, right?
In the sanctity of their home, instead of having
some person,
some public servant, and who knows what kind of
setting, etc. Yeah. So anyway, we could go on that topic forever. But so they tried to pull these books, and it took them almost a year plus of challenging the library director and saying, just put it in the back, put it up top, put it somewhere else. Just don't put it where our kids can see it. And eventually it turned into petitioning the government, which is a right under both the U.S. and state constitutions to petition the government for redress. They filed signatures and had a ballot measure that was going to go on this November's ballot with the elections. And an organization filed lawsuit enjoining or stopping the county auditor from actually printing that, and the electioneer from the elections supervisor from eventually potentially certifying that. And it was all about while I'm not a true fan of shutting down, well, I don't mind shutting down most government services, but I don't like shutting down libraries. I think there's a lot of wealth there, but when your librarian or whoever is not willing to work with you to remove books that are truly objectionable. I don't want to say, there are some books that, it's objectionable to me and you, but not everyone else, right? And stuff that you don't want your kids to have. And so I thought it was great that these people had done everything they had. The ballot measure was certified. It was ready to go. Then they get sued to stop it. And the issue here was this organization, Neighbors United, sued not just the county officials in their official capacity, meaning there could be no damages attached to them, but they also sued one of the individuals who drafted the petition and assisted with it. She collected signatures early on, and then that petition had some issues because it had people residing in city districts and it had to be unincorporated. So in the last 48 hours, they collected, not she, but some colleagues collected adequate signatures. And so she wasn't even a signature gatherer for the important documents. She was just kind of one of the mouthpieces. And so they named her personally and talked about fraud. And, I looked at this and I said, all right, let's fight this. Let's fight this. Let's fight this. And I said, but there's risk, and there's risk to you, not the auditor, not to anyone else. If there are ever attorney's fees, if there are damages award, especially if, not that I think fraud would have ever been proven. In fact, I think we had adequate evidence to disprove it and potentially countersue. I mean, and there's all this stuff that goes through my head of like, oh, we'll sue them this and we'll do this, but there's still risk, and that's not my money. It's not my skin in the game. It's hers. And so we represented her, and our goal was to try to get her out of the case so that, there's no risk to her, to her family. And it looks like, as of earlier today, we reached an agreement to dismiss her, which I think is awesome. And that's not to say that the outcome will be perfect. I don't know. The prosecuting attorney still has to defend the county individuals. Certainly, there's no question that somebody else could intervene on that position's behalf of, hey, we want this ballot measure to go forward. But, it's always fun and games until your skin's in the game. And then, the tough conversations that you and I have to have with clients and folks that come in here is like, what are you willing to lose? And she was certainly willing to lose a lot. But I also said, look, there could be more at risk than what you want. And I have to advise on the risk. And, the group was like, well, yeah, get her out of there and we'll figure out how to deal with this. And so again, it looks like it was signed. It was supposed to get filed. We've removed her from the case. And, the way that she's removed, all claims related to her should go too. So it'll be interesting to see how that case is litigated. I think we'll watch that from afar and probably continually report on it, because I think there are some moving parts that intrigue me. So hopefully that will be done and taken care of, and she can sleep well at night and find a way to fight for the same issues in her community. And I know she will.
Good. So, let's just talk about kind of the buzzwords that came out of that. Obviously, that she petitioned the government. She went through all the right channels to do what she was trying to do. Right. She spent the time that was necessary to speak with the library to see if they could resolve it, locally. And the way I understand it, was multiple chances, multiple different ways that they could have resolved it, and just received pushback the entire way. Did the research to understand what it would take to petition and get the funds back, in funding of the library back into local control, so that they could then make the decision themselves as a community. And then she was slapped by a lawsuit for having done everything that she would do as a responsible citizen of a community.
Exactly. And the reason I'm looking at my phone is because literally as we're talking about this, I just got the confirmation. So it's good to know that that's put to rest and we're protecting her. And to your point, there are lawsuits, and we actually asserted these defenses. It's anti-SLAPP, which means it's you can't sue somebody for their public participation. That's really what it boils down to. And in this case, her public participation was petitioning the government. Now, obviously, if true that she fraudulently procured signatures, or if true that you defamed someone in your public participation, those are defenses against an anti-SLAPP lawsuit. And here, again, obviously there were fraud allegations, but again, those would not have stood well against the test of the court. And so it's one of those bittersweet ones where, we defended someone, or she was a defendant in this case. We helped defend somebody. We helped remove her from the case, but it would have been fun to keep going and get to the merits of the issue. But there's always another day with somebody else's skin, or theoretically no one other than the organizations, right? That's why we have the organization. It gives us an opportunity to sue on behalf of our plaintiffs, on behalf of our donors, and say, hey, look, the organization will stand in your place. We know this is your complaint, and you don't have to have any personal liability.
Right. No, that's great. The other thing that came out of this, I stand with you as far as I think libraries are great. I was an avid reader growing up. I was able to, build worlds in my mind when I was reading books, and was introduced to ideas and things that were outside of the small community that I grew up in. And so when someone accuses somebody of being a book burner or anti-knowledge or idea, it really rubs me the wrong way. And that's I hate that in this particular case they're being portrayed in that way. That's not at all what they were trying to do with what they're doing with removing those books. They just wanted those books put somewhere else. Not that they want them destroyed, not that they wanted them taken out of existence. They just didn't want them to be in the way of children that could get them and be influenced negatively in a way that they didn't want them to be.
Yeah, exactly. And I think we have rights as parents to have that type of objectionable material. I didn't see the books. The claims were some were pornographic. I've seen some of the pictures of the books, and I've read some of the words out of the books that allegedly, or that aren't allegedly, that are being shared with our kids in school. Maybe not yours and mine, given where their schools are. I want to be clear about that. But
Right.
generally in public school, words that even I wouldn't feel comfortable. I certainly wouldn't feel comfortable saying to my kids.
Right. And the reason why I'm bringing this up or coming on from this angle on this particular case is that we wholeheartedly believe in the First Amendment and the right to speech, the right to believe the way you want to believe. It's just there are certain limits to what a cultured society should have, and our children should not be part of that discussion.
Well, absolutely. I mean, none of us, I'm not going to say none of us, but you and I don't disagree with having a rating for our movies that gives us guidance. Now we can have the choice to ignore it or to say that's too far. An R-rated movie for my 5-year-old, back in the 80s, maybe way, way, way different than what we see now, or a PG movie even. There's some pretty moderately innocent that have maybe nudity I don't want to expose my kid to, or they drop a couple swear words that I don't want them to hear, whatever the case is. But there are guidelines that we've all kind of grown accustomed to, and quite frankly, kind of tacitly agreed to, and said, oh, okay, that rating system's okay. So why can't that rating system be applied rather than for what you see, but what you read? And that's fundamentally what was being asked here is like, look, this is beyond R-rated. We believe it's X-rated. Just get it out of kids' reaches,
Right.
And if a kid wants to find something, kids are resourceful. They'll find a way. They'll scaffold the shelves, whatever they'll do. If they see it and they're intrigued by it, they'll find it. But it doesn't have to be right there.
Right. It doesn't have to be introduced or given to them or easily accessible.
And just one other point on that case, the First Amendment protects your right to petition the government. It's not just your right to free speech, right? Right to petition and assemblage. So you can congregate and you can ask your government for help. And that's exactly one of the corollaries, ironically, utilizing the right to petition to say, this is speech that's not okay. So.
Yeah, no, 100%. I know that it was just something that when we both were introduced to this case, I know we both were looking at it and trying to look at it from every different angle and make sure that it was the right case for us to go on. And I think we both landed on the fact that we started this foundation primarily because we wanted a good future for our children, and anything that is attacking that and threatening to take away the innocence of children is something worthy going after. So we have our next topic, which follows along another First Amendment issue. Dr. Wilkinson out of Yakima has been battling to keep his name, clean and clear, his license clean and clear for him to be able to practice and to be able to really serve his patients to his full capacity. And we just filed something for him this week. Can you walk us through that?
Yeah, so we filed a notice of appeal to the Yakima County Superior Court, and we are appealing the Washington Medical Commission's decision to put him on a 5-year probation, which limited him from prescribing ivermectin and off-label uses. A couple other things had to do some educational kind of re-education camp stuff, writing an essay, I believe, and a $15,000 fine. We're filing that because we're consistently seeing with our other cases that courts won't touch the constitutional arguments on whether or not the COVID-19 misinformation position statement from the Washington Medical Commission, which adopted a standard of care that COVID misinformation is in violation of the standard of care, and that treating with ivermectin was also in violation of the standard of the care. The courts will not hear these cases on their merits until there's a quote unquote final order. Well, then the claim is, okay, well, you went to the Washington Medical Commission's own kangaroo court where they tried, they were your jury, judge, and executioner, they're experts, all of that paid for and provided by the state, your taxpayer dollars, and the medical commission. And so, we're like, listen, Your Honor, we got a final order here for him. It is appealable. And it's like, well, you can't challenge the COVID statement until you've gone through and exercised your appellate rights. It's like, all right. So now I got to put time in the Yakima County Superior Court and then potentially appeal it to the Court of Appeals and then potentially the Supreme Court. And then when it's moot, we can get back to the COVID position statement because we know people will have enforcement actions until that statement is dead. And so circling back to Wilkinson, he has this final order, which isn't final allegedly, and we appeal it to the Yakima County Superior Court. And so we're looking forward to that. These types of appellate matters are based on what's called the record. So everything that happened in his 5-day trial is going to come right back to life. And all the briefing, all the testimonies and witnesses, opening and closing arguments are all going to be displayed on transcript in some way or shape or form. And we're going to argue that the medical commission erred here, and here. I think we had outlined like 9 points where we believe they erred. And say, okay, you're a real judge. What do you think about this? So it's a frustrating system, but it's the system we have. And, it's just the next step.
Well, from a legal perspective and where we've come in the last 3 years after COVID, it's exciting to see that we're getting somewhere. I know to your point about it possibly could go through layers and layers of court, but it is moving in the right direction. We are getting some decisions, and hopefully we can get through this with the doctor's license being free and clear, and none of those penalties being applied to them. And I talked to Karen, the other attorney on this case, earlier today, and she made a point that she very strongly disagrees with the re-education camps that they're requiring these doctors to go to.
Yeah, I mean, they're all pieces of this order are offensive. I mean, there's really no two ways about it. But certainly that element is extremely frustrating because here you have a doctor who's practiced 40, don't quote me, but like 5 or 7 years. So longer than either you or I have been alive. And they're saying that he's not doing it right because he's willing to look at the science and say it's bunk. I mean, that's really all he did was say, government, you're BSing me. My science is this. And as the story goes, he kept almost all of his patients out of the hospital. And guess which one died? The older, more frail gentleman who went into the hospital and was treated with remdesivir.
Right.
Shocker. How many times have we heard that story over and over and over? And I should just stop now before I have to say it like thousands of times, but over again.
But that's the human element of what we're doing is how many of those people that we came into contact with prior to them going to the hospital and they're no longer with us. It's really quite shocking and saddening and really heartbreaking in this work that we've chosen to take on, to see what went on with that. But hopefully we'll get some justice sometime,
I think it's there. It's happening. I mean, our corollary to the Washington Medical Commission's COVID-19 misinformation position statement, which is California Assembly Bill 2098, which actually adopted by the legislature, like enacted in a law, COVID misinformation is a criminal violation. I'll be honest, I've touched on the reading. There are several articles about this, but it looks like the state assembly in California is walking that back. And that's all due to 5 doctors who were willing to litigate the issue. And so it sucks because, I mean, fortunately they weren't punished, right? And that was part of the argument is like, you haven't been punished yet. This doesn't matter. It's not ripe, which is the exact opposite of moot. Like, until you're harmed, you can't sue, which is BS. And obviously plenty of people were harmed by that. But it does look like, you're going to be scared of the next variant, or scare tactics will be used on the next variant. But it does look like some of these states like Washington and California are starting to catch up a little bit on the, oh, crap, like we're going to be hugely exposed.
Right. So, unless you got anything else on that, no. I think the item on the agenda that I've been most excited about getting to is our case with Gators Custom Guns out of Kelso in Cowlitz County, Washington. If anybody's following our Second Amendment work, this is a group that did what I don't think anybody else was really willing to do. As far as, I mean, the AG's been looking for them all over the state, and so far really only found a few that were willing to buck the law, so-called law about of banning large capacity magazines. But Gators Guns is being accused of selling large capacity magazines, contrary to the SB 5078, which we also have a federal case against.
Yeah, and I mean, so this is like our full Second Amendment world coming full circle. As you mentioned, Senate Bill 5078 bars the sales, offer for sales, manufacture, importation, distribution of any magazine greater than 10 rounds. And this was adopted in 2021 and effective in 22. And we filed a lawsuit over a year ago. And we've been waiting on an opinion from the court that was 30 days out as of Thanksgiving of last year. So maybe, I don't know, maybe we'll eat turkey this year, right? And so we challenged it in federal court. Other people have challenged it in federal court. I want to say maybe it's been challenged in state court. But there's always been this like, oh, well, it's not arms. It's not, the Bruin test doesn't apply. And it's like, oh, it's BS. Or they're just lagging it out like in our case and there's no decision. So fast forward to recently, Gators Custom Guns gets what's called a civil investigative demand, which is the AG, the Attorney General, saying, hey, you're a gun shop. I think you've sold some magazines. Why don't you tell us what they are? So Gators gets that, contacts us. We file a motion for preliminary injunction. In other words, asking to stop Gators from having to, basically saying, Attorney General, stop. You can't enforce this. And we sought what's also called declaratory relief, which is courts tell the AG that this is illegal because the law sucks and it's unconstitutional. Mostly because it's unconstitutional, but does suck. And so we file that. And I don't know, maybe a month and a half's gone by since we filed that to defend. And really kind of crickets. We were going to tee up a motion. Well, over the past 2 days, the AG's office files what's called a motion to dismiss that case, saying, oh, well, the Silent Majority Foundation's wrong here. This isn't unconstitutional. It's total BS. Gators was late in responding, and there's a whole question about when it was served, when it wasn't served, stuff like that. So there are a lot of interesting questions before the court on the civil investigative demand, including that of us challenging the constitutionality of 5078. And I'll be honest, I haven't read everything, but as I understand, the Attorney General from Austin Hatcher, our other attorney, he said that the Attorney General basically argued, well, this is moot, as we talked about. It's a dead issue because we sued him anyway, And so it's like, if we can get the AG to stipulate to some sort of like they've really dismissed the CID, one, that's a win.
Yeah.
That's a win because now they don't have to show their hand. They don't have to talk about it. They don't have to do anything about it. Now, of course, they're being sued for allegations of some sort of 11,000 magazines plus. Now, it's not clear as to whether the AG believes they have evidence that those were sold, but certainly transported. Is there's an allegation that 11,000 plus magazines that violate the Consumer Protection Act. And we've done a lot of research on this. We were defending another organization, and we dug into the statute. We dug into the history. I mean, nice thing is it's 2 years old, so you can literally watch testimony that was live at the time.
Right.
And you can watch the senators and the House members debate it. And you can pull a lot of nuggets out of that. And we did. We did in that case. And that was in King County, and we got a typical King County judge. We're in Cowlitz County. That could really change the makeup. I guarantee what we're going to hear from the AG's office is, well, Judge Scott in King County said that this is totally kosher. Like, I mean, they might as well just say that.
Right.
And a Cowlitz County judge, if what you would expect out of Cowlitz County is what we see, you're going to be like, well, I don't give a shit. I don't care what King County says. Let the King County judge do what they're going to do, but I have the same type of jurisdiction over my county. Mm-hmm. And we've talked about this. The Court of Appeals and the Supreme Court want these cases to come up like this, right? Mm-hmm. You have 39 counties, 3 courts of appeal, and then a Supreme Court.
Right.
What we're seeing with our cases is they go like this. And it's Well, you sued us and you named the governor. It's got to go to Thurston, up to 3, and then up to the Supreme Court. So you're backlogging cases. You're backlogging cases in Thurston County and the Court of Appeals up there. 2, you're getting all the same people making decisions, as opposed to, hey, 39 counties that technically are independent. Yeah. And they elect them independently, and the electorate doesn't have a say because it's all going up there. I don't elect anyone in Thurston. Heck, if I could, I probably would.
Right.
Because I got enough cases. I probably know more about the judges up there than most Thurston County residents.
They're making more decisions for us than our judges are.
Yeah. And so with Gators, we've got these 2 fights, the civil investigative demands, and that's going to be heard in this month on the 27th, I believe. And it's going to be interesting to really see how that plays out. The question is whether or not the AG has overplayed his hand, both in the way he talked about the civil investigative demand, or his attorneys, his assistants, and in how they're pursuing this. Because I think now, here's the beauty of this case. As I mentioned, we're continually seeing the courts do this, right? Mm-hmm. Well, now we're here in Cowlitz.
Right.
Technically like here. But we're not going through the same avenue of Thurston County judges. And that may, I'm not going to say it will, but that may change the decision-making process and how the judges see constitutional rights. I'm hopeful that it will.
Yeah.
I believe it will.
Yeah. You think that, I mean, history, if anybody's jumping in with us right now, we originally brought a case in Grant County where we had a judge who refused to rule on it based on everything Pete's been saying. And it was really, disheartening to see a judge refuse to rule on the constitutionality of that law for his constituents. Everybody that was named as a plaintiff in that was a resident of Grant County and fully expected that a judge in Grant County would hear their complaint. And he refused to. And I'm not afraid to say that he absolutely missed the boat and absolutely was a coward in making the decision he made. And I know that you don't necessarily need to make a comment about the court, but I absolutely feel like that was the most cowardly decision he could have made and set us back months, if not years now, in this fight for a Second Amendment rights here in the state.
Yeah. I'm not going to disagree with any of that, so I'll leave it there. It's extremely frustrating that we get these cases, and we have 39 independent. Now, granted, some counties share, so whatever. Elected bodies of judges that we want to hear from. And it's not just we want to avoid the west side of the state, which we do, but we also want to hear from judges here. I mean, we've had different opinions out of Franklin County than what we may have seen out of Thurston County on cases. Clearly, Johnson versus Inslee, that's a case in point. And so I'm excited. I'm excited to see where this goes. I'm hopeful that this will be a turning point in the Second Amendment fight here in the state of Washington. We've intentionally, when we've challenged the civil investigative demand, we intentionally brought it with certain state claims and then brought in the Bruin analysis so that we had the right way to appeal it. And it's just going to be really interesting to see how this plays out. And again, I'm hopeful because the state cannot move this to Thurston County. So we are in Cowlitz County, period. And it'll be interesting to see if those Cowlitz County judges read the statutes the way that we read them, like when it says, online, it's a important word. Online sales are prohibited. And we made that argument in King County, and the judge is like, well, online doesn't really matter. It's like, well, then why did the legislature say that? Pretty sure you're wearing a black robe, not a suit and tie in Olympia. You're in King County, man. And so he just basically dismissed, online sales. Like, what else could that have meant?
Right.
He alleged, because our argument was The client there had no online presence, and it did have an online presence, but it didn't sell. Same thing with Gators. No sales online. It's going to be interesting to see if we have a judge who's, intellectually adequate, that actually reads that word and says, this matters.
Yeah.
And then great, let's fight it out in the appellate court. Let's fight it out in the Supreme Court. And if we can get the right analysis and say that under Bruin they screwed it up, we may even be able to get to the real Supreme Court. Yeah. I mean, there's a lot of cool stuff with this case.
So we've got some people chatting with us. It's been pretty cool. We've had consistently between 12 and 20 viewers since we've been on Facebook Live. Probably more viewers out elsewhere. But one of the questions actually was, how do we get good people to run for judge? Why are so many judges running unopposed?
Yeah, it's a question that I ask myself, right? Like, why don't I do it, right? One, I'll speak for myself. I can't speak for everyone else. I would be bored as a judge. I really would. I mean, like sitting there and then just making rulings and like listening to people, man, that would be boring to me.
No, you got to listen to the wrong side.
Well, yeah, you got to listen to it all, and then you write something, or you have the parties write it for you, and then you sign off on it. So one, it could be the type of work. Two, there are a lot of people that make well more than judges. Now, I will tell you this, that I don't qualify as that one, right? Judges are making like $200K plus for Superior Court judges, plus a solid retirement.
Right.
So to me, it should be attractive. It should be attractive to, someone with my experience at 15 years. I've maybe less litigation, but, just only a handful of years of that as opposed to 15 years of practicing law. It would seem to think that this could be a decent place, but I think people look at the earning potential and you're capped, and those are probably the big things. I think if you can get a very civically minded person that wants to make that difference, then yeah, you get behind that person. But I really don't have a good answer as to why folks. And the other thing too is, I mean, can you imagine running for judge, especially in a small community, and losing? What that could do to your employment prospects?
Yeah, it's tough. I can understand. So actually, Rachel Cisneros chimed in and said more money in the private sector. So I think people understand. I think that that clearly there's more opportunity financially, in the private sector and doing law for yourself versus serving the public. And then Kat Snyder says she appreciates what you guys are doing. Thanks, Kat. We appreciate everyone who's listening and following us and supporting us. We understand that this is all of us together. We just had the fortunate ability to do what we're doing, and dedicate ourselves to this. But we know that everybody is chipping in as part of this fight and working towards that. So overall, how do you feel that the Second Amendment fight is going in the state of Washington, or do you think that it may be decided elsewhere, or do you think that we have a chance to crack into the Supreme Court ourselves?
I think there will be a chance. I don't know that it's going to be any of these cases, to be honest. Certainly unless our Yakima, our federal 5078 gets decided soon. I think that could easily become one of the ones that really takes the forefront. We know that other states, Oregon, Illinois, other states have had these magazine bans, and the Supreme Court's declined to do emergency stays. But I think we're going to be part of the mix. Whether or not we're the leading edge of the sword, I don't know. But I think we are changing the landscape. I mean, I remember seeing some of these civil investigative demands. The Gators was like the fourth or fifth one we've been presented, and probably the third or fourth that we've represented. Mm-hmm. It went from 8 or 9 questions down to just one. And I think the reality is this is the same thing we've said about our medical freedom cases. The way the state's approaching this is the hand in the cookie jar approach, right? Not just I'm going to take all I can, but the mom saw me do it, so I got to be sneakier, or I got to do it at a different time. And I think that's what we're seeing with all of our fights, right? Again, especially that medical freedom and the enforcement of these gun laws, which I hate calling them that, these gun ideas, I think we're getting there. So I know people are like, man, we should have had a decision before. Yeah, we should have had a decision out of Grant County. That's why we're there. We didn't. The fact is, we did not get the decision. At that point, it got punted to Thurston, and now we're in this role. We had our preliminary injunction was denied, and we have the opportunity to either pursue a permanent injunction with a little bit more evidence, or we can appeal that decision. And, stay tuned for what we do with it. But we're going to continually move the ball because we know that if we just stop, then next year's going to suck. And the year after is going to be worse until it's, you've made this comment. Like, if we're lucky, we'll be left with revolvers.
Right.
6, it'll be a 5 shooter because a 6 is a large capacity revolver.
Six is too many. That's too dangerous.
Right. And there's, of course, like all these laws, it's all arbitrary. There's nothing to support any evidence. So yeah, I do think that we are having successes. I want folks to be, okay, so SMF V Inslee's dead, but, we're still fighting for your constitutional rights. We're still fighting the government. We're still fighting the same people that issued these things. And we are ready for the next COVID,
Right.
And I know people, certainly the people that are willing to stick around for almost an hour with us aren't going to call us conspiracy theorists, but I know that people are, oh yeah, it's not going to happen. It's like, that's why you're getting shot. Like you said earlier, shot warnings. And
yeah, well, that's what we said last. Yeah, I think every time we say, oh, they can't push it that far. Oh, they can't go that far. Oh, and every single time they step one step closer, one fence, one line over the next. Well, great. I think we've had a good conversation. Got a pretty good update. I just want to really go back and highlight and actually shout out wins. I know it's a negative connotation to say that SMF V Inslee's dead, but we made some headway there. We've got some good arguments. That stuff is recorded in the courts, and we can bring it back when the next time Inslee oversteps his bounds or whatever governor comes in next. We have some ammunition against them. Same thing for OSPI. They told us, we have their attorney on record saying, oh, we're not going to bring masks back again. That's not going to happen. We've got that. That's another feather in a cap, another win that we had that we can take right back at them if they try to push it against us. Got this great win this week with our client out of Dayton. Got her out of that case. No personal liability or risk that she had. And that case is going to be fought where it should be fought, in the government, where it was intended to be, and they're gonna get a decision about where that library is going to end up. But what's important is I think the principle and the moral victory there, that parents stood up and were fighting for what they believe was right for their children and for their community. So we've got some great highlights. We've got some great wins. Those of you that are supporting us and following along with us, it's because of you that we're able to continue to fight for freedom, to fight for our constitutional rights, to fight for our morals, our integrity, our religion. And we thank you so much for your support and everything you do. Pete, some parting advice, wisdom for us today?
Yeah, I mean, just circling back to SMF V Inslee, it's dead is its mootness. And I know this is really the lawyer in me talking about it, but they didn't say that the COVID proclamation was okay. They said that it had gone away and there's no value, and I'm putting words in the court's mouth, there's no value in the court opining on it. It's not ready to be opined on. And that's a critical distinction, because it doesn't mean that we can't bring that same gun to a knife fight, right? Doesn't mean we can't bring it back when there are more proclamations issued. To your point, this really gave us a roadmap. Not that I want to be the guys that challenge those fire ones, but I kind of want to be the guys that challenge those fire ones, because I think then we can start boxing in the analysis required. So, even when things don't go our way, there is learning and there's experience. I've said this all along. Okay, next time masks, OSPI versus Reichdahl, you mentioned that. Next time our kids have masks or some other quote unquote health requirement, we know how, where, and when to strike. We know that. The government has our resources. Until we stop giving it our tax money, it's going to have the quote unquote largest law firm in the state with resources that are always rolling in. Payroll will be met.
Right.
It will be. And we're going to keep fighting that Goliath. You know, it's not, unfortunately, not the David. We don't have the rock and the sling and the forehead, right? But we are still slinging rocks, and Goliath isn't maybe charging as hard or is charging differently than it would have but for those rocks. And so take heart that we're moving the needle, you know, and again, to your point, shout out to everyone supporting us. We couldn't and wouldn't do this without you. And we, you know, we make sure that we keep our staff as lean as possible. We've got people that want to join us. I know for our birthday, we put out a big ask. And, you know, quite frankly, I was a little disheartened. You know, it's hard to have an ask of like, here, $200K buys us one more attorney for a year, right? And another staff. And maybe, you know, helping out some of the awesome attorneys, you know, where we can that are helping us. And I know that's a lot of money to try to raise, but it's what we need to protect your rights. You know, we're not trying to do this to get rich or greedy. As was said, why don't people run for judgeship? More money in the private sector. As I mentioned, you know, we make much less than that. And I'm not crying myself to sleep. I'm not disappointed. God asked me to do this. You and I are doing this. Our attorneys have jumped on board. Ryan and Katie, all of our other supporters have jumped on board. They've seen the call, but please, please keep bringing that money in because we need it and we will keep fighting.
Right.
You know, we're not dead. We might be moot. We're not dead.
Yeah. And a lot of you ask us, it's continually asking, what can I do? I'd like to help. What can I do? The easiest thing for you to do is share our story. Share to everybody about what we're doing, who we are, Silent Majority Foundation, working for your rights. Feel free to email us, info@silentmajorityfoundation.org. Interact with our social medias. We know we get shadow banned or suppressed by the socials. Unfortunately, it's the best way to reach you and stay relevant. But if you continue to share and push our message, who we are, with anybody and everybody, that it just makes us all stronger as we work together, get bigger, and have more people, more support. We're gonna that loneliness or that sense of impending doom that some of us have right now with what's going on, and I don't even know how to put the words to sometimes the emotions that we feel in this fight. I don't like to be negative, so I can't think of the words, but always positive, always looking forward. But share it, tell everybody about us, and thanks for listening. If you stuck around the whole time, you're amazing. If you jumped on and give us a comment, thank you. Interaction is great. We're trying to do this more often. More comments, more interaction, questions are very, very welcome. If you have questions for Pete or our legal team, this is the time to do it, where we've set aside time to talk and interact with our followers. So this is why we're here. We want to inform you, let you know what we're doing, where your support's going. So please give us questions and feel free to submit them via email or on our Facebook page. If you got questions about certain topics, we'll definitely bring those up and talk about them. So thanks for listening, and until next time, stay safe.